important topic, and I mean, lot discussions have happened around it, but let us see where we take it. And that's Elizaveta. She's in I always say she's in Siberia. She's in that part of Russia, and Nicola is in Serbia. So that's how it is. So what I'm going to do now, right now, is Nicola, I'm going to put up that little poster of the uh, conference. You have to tell us about the conference.
Yeah.
Yes.
Sure.
What is? Please.
So the conference is a worldly live event for all mediators and people who are not mediators to join in, listen in, maybe learn a couple of things, maybe find out a couple of things, and to connect with the world of mediation even harder. As for the Mediation Vision 2026, that's something that we mediators must all discuss live with everyone to find out where we want mediation to be and where do everybody else see mediation in 4 years, sorry, and see how we can get there. Ken Cloke was the opening speaker. It's a pleasure, always a pleasure to listen in what the pioneers of mediation have to say. And Vikram has been doing a marvelous job in getting it all together and pushing everybody to be the best version of themselves. Hello, Elizaveta. I'm sorry I didn't say hello earlier.
That's great, Nicola. That's so nice. I'm never now going to introduce the conference. We are going to call Nicola to introduce the conference. So perfect. Now, only thing is that the schedule is out there on social media. So obviously, we've done now. This is now the, I think this is the 42nd session, and of course we have more than 70 to happen. So Nicola, this is mandatory mediation, to push or not to push. So please.
Well, as for the mandatory mediation, that's a bit of a tough subject for everybody. I believe there's still that's still an ongoing dispute, and it's very lively. It receives a great bit of support and a great bit of backlash, so to speak, and opposition from everybody, because everybody is trying to find a way to make litigation easier. But I believe that mandatory mediation should be something, and that is part of my Mediation 2026 vision, that mediation should be mandatory in most cases, not just mandatory as in first initial meeting as the EU regulation states, but mandatory as such, because this is the part where we are trying to make people's lives easier. We are trying to get things done quickly. In today's time, I never met a person who says, yeah, I have 5 years to wait for a dispute to end or a conflict to end. They want it done and resolved quickly. And that's why this idea should work. And this idea should be very, very beneficial for everybody, not just the mediators, but everybody else. That's my
Situation. Of course, I'm on the other side of it. For me, the situation is that the whole aspect of mandatory mediation came up only because the courts were inefficient. That's the only reason that this aspect came up. So
yes.
What has happened is the focus has now moved away very nicely. The courts have moved the focus towards mediation, and they're not getting their house in order. I'm telling you, I'll give you an example of India. I'll give you an example.
Okay.
Here, our Chief Justice goes out and he, of course, I mean, this was the last Chief Justice, goes out, mediation and all. Then he makes a committee to draft the mediation bill, which I find really surprising. That what do you have to do with mediation? Stay away from it is what my thing is. Then on top of that, when you have to put your house in order, you look at the civil procedure code to see where are the issues, where is the time being taken, what is really happening in the court system. Our civil procedure code is 1908. We got independence in 1947. You are not willing to put your house in order, and here you want to go about getting the government to draft it in a certain manner, just because you have a self-interest to do it. So I'm saying what has really happened is it's become an outlet for them to stay inefficient. I'm saying we should put pressure on them that you have to become efficient, you have to deliver justice. You're not delivering justice. I mean, wherever I think, even in, of course, Italy is this whole model of going out. I don't know. I can't say what the situation in the court system, how much time it takes. But in the last symposium, there was Chuck. Chuck is from Israel, but he's based now in Berlin. So he says that in Germany, mediation has not taken off because the courts are really efficient. So
Yes.
I'm saying that if you get your house in order, after that, if mediation has to develop or not develop, leave that to the people. Do not say that we are going to be what we are, but we are going to force you into mediation. I have a problem with that part.
I have to ask you one question. What is justice?
In the sense of the courts dispensing justice, or in
No, we're discussing
in a matter?
We're discussing justice here. The courts, you said that the courts have to deliver justice.
Yeah.
What is justice in that sense?
Look, let's look at justice. I have a certain claim against someone. Okay. My claim is legitimate. Now I want that justice first is two parts. One, of course, what my case is gets heard properly and I get an order which justifies my situation. The other thing is I get it on time. Both aspects come under justice. So the point is that I was talking to someone on this aspect of, or the aspect of, she said, mediation is access to justice. I said, how do you say it's access to justice? There is this person, I was giving an example, there's this supplier to a large corporation in the US, she's from the US, and these people don't pay him or her or whatever gender, don't pay her. Now the point is he can go to court. If he goes to court, you know what the situation is. First, of course, time, forget the time. There is a cost to that, and it's huge. For lawyers, it's huge. For that person, it's a gamble, because obviously it's not that you know that you're going to get something in your favor or not. But the other side can play that game, the whole gamble that, okay, we've got this cost. This person knows if I don't get an order in my favor here, it goes against me, I have to pay their costs, which is going to be huge. So under pressure, the person goes for mediation. Is that the way we want to send people for mediation? Are we not going to make the, as we call it, the justice system in a situation that person is not kept away from it, is not scared of it? This is someone in Australia was also talking about it with me again. This is last year. This aspect that a person is not going to go in for litigation and will go in for mediation only because they don't want to play the gamble. It's a huge gamble to play for someone, and the amounts involved might be less than the amount that you might have to pay for costs. Who knows what the situation is going to be? So in that sense, when you send someone down for mediation in this way, you're actually, with this whole concept, you're playing into the hands of people who know they can get away with that gamble because they have that money power to handle that.
Yes.
So those are the things that we also have to consider when we talk about justice as such. I don't know what your thoughts on that are. We'll get Elizabeth also after this. Elizabeth, you also please come in, but let Nicola give his thoughts on
Well, I
this.
think that if you need your day in court and you need to be heard, you can be and you will be heard in mediation. That's the whole point of mediation, for everybody to speak their mind. And you want somebody to rule on damages. When we talk about justice, we usually have the Roman goddess Justitia in mind, with the blindfold and the sword and the everything. And in the end, the whole point is that justice is fair. In the current court system, wherever you are sitting, whether it's the States or somewhere in South America, Africa, Asia, Europe, never mind. How many people have you heard that said that the final judgment was fair? Everybody appeals to the initial ruling. Yeah. The plaintiff is not satisfied. The accused party is not satisfied. Nobody is satisfied. They go to appeal, And after a couple of more years in court, in which they do not effectively, maybe do not effectively go to court, they just send documents for review, and the appellate court gives a final ruling. And you cannot do anything about it. So you have to settle for whatever somebody else told you
Exactly.
that you have to settle for.
That's what I'm saying. Nicola, this is what you have to consider, that when a person is going for mediation, and in mediation, everyone tells them, oh, this is going to take so much time in litigation, it is going to cost you so much. So you should consider all those aspects when you are sitting down to negotiate and settle it. In a way, what have you done? You made the person give up a claim to a certain point. Look, someone had a claim. He started off with some claim, but we said, look, these are the factors. What are the factors? The inefficiency of the justice system, as we call it. Let's call that the court. Let's call it the court system. Let's not even call it the justice system. The inefficiencies of the court system is what we tell them are the reasons why you should go for mediation. That's a very major factor of it. Forget all this whole relationship and all those aspects. If those were the things, the criteria, the mediation as we know it would have developed in the US also and other places. That did not happen. Largely it's that deal making activity. Okay, how much can you give, what are the factors behind it, what are the things we can show you in relation to cost and time, and based on that, this seems all right for you. We show people that, okay, this, I mean, of course, in our country, definitely the cases go on for a very long time. So we show them that maybe it might take 15 years. I mean, that's the kind of time span that you have here. Maybe more. I'm just saying 15 years. There's one matter which was already 14 years and it would have taken another 10 years. So those are the time factors you're showing them. But the time factor we are showing them because of the inefficiency of a system. Either you forget this. I'm saying forget this entire court system, which is a colonial legacy. Why should you the state set up something for people for their private disputes, commercial disputes? Why should you be setting it up? They can, what is arbitration? You set up your own court. It's your dispute. You got into a dispute. You find a person to be your judge. Let's totally relook the whole concept of the court system. I'm okay with that. But if the court system exists in the way it exists, in that sense, to send them out of it based on the fact that you are inefficient, I find that something which is, according to me, a double standard or whatever. I don't know. I'm not going to maybe the right words.
When you look at arbitration, the whole process showed up because of the inefficiency of the court system.
Exactly.
And people wanted their day in court. People wanted to be heard. People wanted for somebody else to settle the claim. And that's the thing that's been going on for about 100 years or so.
Yep.
And when you look at arbitration, and it was fast, it was cheap, it was good for everybody. Somebody made the decision, said who is right, who is wrong, and that's it. And when you look at arbitration today, it's the same as the courts.
Why did that? No, one is
it's even more expensive than the courts.
Exactly.
And
the worst part is, no, Nicola, the worst part is that after that the matter then goes back into court, and then again it takes a long time. So there also the court system has destroyed arbitration. Because those matters are lying in our courts. You can't even imagine for how many years they're lying in courts because the award was challenged. Then the judgments keep coming up. The Supreme Court on our case keeps saying, okay, these are the things that the court can look into. These things they can't look into. And that whole refining process is still going on. But that doesn't help. You might refine it to a point that it might not take 10 years. It might take 5 years. That's huge after the person has gone through a process which was supposed to be much faster and there was a finality to it. The court system didn't leave a finality there also and did not improve their efficiency on this. So I'm saying that again, finally, it all comes down to the inefficiency of the court. Arbitration was maybe, like you said, a good concept. You found your own judge. It was your judge. You got the judge. The flexible process that you wanted to follow, you followed.
Yes.
You did it the way you wanted to do it. After that, if that award if that also is not acceptable to you, then obviously the whole concept fails, because after that next stage you are going to back into court. So that's why people are now looking at that. But what we'll do is let's get Elizabetha into this. Elizabetha, something that you want to please bring in from your experience?
Thank you, Vikram. I will try to tell it in English. As you know, I also have to translate it. As I see, Nicola is he wants mediation became mandatory, and Vikram is usually against this idea. And what about me? So I haven't a strong position in this question because I see some positive and negative sides in it. In Russia now, we haven't mandatory mediation at all. And 2 years ago, we had a draft of law which wanted to correct our law about mediation. And there also was positions about mandatory mediation in family cases, but it's still not work. This draft, we haven't such law positions. But when I'm thinking about this topic, I see that on one side, I maybe agree with Nicole, what any mediator wants to become mediation mandatory in such cases where you want people to know about this procedure. Each of us wants people and organizations know about mediation and know about it when they only come in conflict. And in this case, maybe it will be some positive side of mandatory mediation, because if people come to the courts and they get information what they must do, they must go to mediator and to try to solve the conflicts by themselves with the help of mediator. And in this way, of course, I like this idea because maybe some more people will know about mediation. But on the other side, I know what there may be a lot of problems which consist in worldview of our population. Maybe in different countries, this question will work in different ways. But the first reasons which I see like negative is that principles of mediation is that mediation must be voluntary. We may choose it by ourselves to go to mediation or not. It is our good will. And I'm afraid that if we will get mandatory mediation, maybe this principle will not work, because in this way, any person have to go to mediator. And as for Russia, I'm afraid what when someone tells us what we must do, there will be a lot of people who don't want to do, as you write, the topic of our conversation, Vikram, to push or not to push on people. And I see that in different questions, when we tell that you must do it in this way, people in my country don't want to do it, even if it may be will be really good for them. For example, when in 2020 we get a pandemic of COVID, and it became a really large problem of vaccination in our country, because I know that in different countries there maybe was problems where to get such medicine help. But in Russia, it was for free, and anyone must go through vaccination. And after that, there was a lot of protests against it. People didn't want it to do, and there was a large quantity of persons who go for vaccination only after then they get sanctions if they don't will go through it. And I'm afraid what's also when people will have to go on mediation only as when the state will push on them, maybe they don't feel understand what does this procedure mean, and they will go against it because they don't want someone to push on them. But I see in also that in maybe in some other countries it will work, not as in our occasion. And also I don't know if we will get such positions in our law. Maybe after some time this situation will change. Maybe in some cases, as I said, as for example in family cases, maybe it really will help, because here people may come to mediator, get a consultation about this procedure, and they can choose to go on it or not. And if they don't want to use it, they just will get a letter from mediator and put it into the court, and they will go to the court later. But only practice will give us will it work or not, because now I don't know how it will work.
If I can weigh in a bit.
Please.
Well, there was a seminar here a couple of years ago, and people spoke about a mandatory first meeting, which is EU legislation, and about Slovenia. And don't hold me, I'm just bought it, sold it. And people spoke at the seminar that the judges in Slovenia are complaining that they are not getting enough cases. They do not have enough work because most cases are settled through mediation. What is done and what is the purpose of mediation? People need to talk it out. We've all been mediators throughout our lives, everybody. You had two friends at school who are fighting and you went to talk with both of them. You maybe had some family members fighting, siblings or whoever, and you went and talked with both of them until they calmed down, settled their conflict and moved along. And in life, when you have a car crash, which has some damage, let's say it's the damage to the car and limited to that, most people get out of the car and say, how can we solve this? Here, we usually go about, I'm going to go to my mechanic or whoever, and you will pay for it. Sure. We have insurance, we have everything, we have the whole system in place, but it's done right then and there. If there's a need for police to come or whatever, people usually stand and talk with each other. That's why and that's the people part. We all are mediators. We all like to talk things through. And when we talk things through, we're happy. We're fine. We get the sense of fairness which mediation provides. And the court system doesn't provide that sense of fairness. It provides justice, but justice is not fair. They do not feel it as a fair justice. And about pushing mediation as mandatory, we are all reluctant to change. I believe that's the issue. Nobody likes to be told what to do. Okay, I agree. But when you make a system which gets them back to their origins and lets them talk it through, the court system will become more efficient because there will be less cases and the people will have a bigger sense of fairness when you make them sit down and talk. That's the whole point of mediation and mandatory mediation. And when you look at Italy, which started in 2011, there's a 4% annual decrease of litigation cases. There's 18% annual increase in mediation, and there's 14% annual increase in settlement agreements. People are getting more and more comfortable. The whole point was, and they only made the first initial meeting mandatory. And people are getting more and more comfortable. And that's the story in every jurisdiction where mediation has become mandatory or mandatory first meeting or whatever. The results are there, and the courts have more time to deal with actually serious. Every case is serious, but some are more complex and some are not. They can deal with complex cases. They can deal with bigger issues, and not being overcrowded and overworked and understaffed. That's the whole point.
No, I tell you, this is what I'm trying to say, that the efficiency of the court system has to be there. Whatever be the situation, whether people go for mediation or not go for mediation, first of all, has to be really clear to the judiciary that you have to be efficient. After that, people should find value in mediation, and they should be wanting to go through that process because, like, whatever reasons, like you said, it is something that they are reaching a certain settlement which seems fair to them. Whatever reasons they are, they have to reach that point that there is find value in it. If they do not find value in it, we have to go into the reasons for that. Is it because the people who are mediators, are they not providing the service that should be provided? Are they not? I mean, if you don't have the right people on that end and you push people into a process, they don't find value in the process. They go back from that court system and then they talk about mediation in a manner where, look, we were forced into it, we went through it, but I will not advise you to do it. What happens in that is that finally, what is our aim? Matters should not come into court. This whole route of going into court and going into mediation seems to be a kind of a temporary thing that we are doing because though they are overloaded. But finally, if we have to see value in the process, people should go for it before they come to the courts. But that is not happening. When I look at it, I keep giving this example of US only because the formal mediation as we know it, that whole word and that court system and all, 40-45 years they've gone through it. Their courts are overloaded there also. Still, 100 million matters going into courts is not a small amount. So we have to, from our side, we keep saying mediation is very good, mediation is very good. Two things are happening. One, like I said, if the user is not getting a good experience out of it, but is going through it only because, like I said, is it because the costs on the other end are too high? The time factor on in the other side is too high, so let's go for it. If that's the reason, and then they're going through it, not coming out in a manner where, yes, they feel, yes, this is a process, I'm going to tell 100 people about it. In the 40-45 years in the US, they should have been, everyone should be going to mediators first and saying, oh, this is the way to go. It's not happening there. So is it that people are not finding value because of the person? Is that a mediator part of it? Because we might be in our mediation world keep saying damn good, but finally it's the user. It is the user's experience. Yes. It's not our experience, it's their experience. So if
the user's experience is changing, that's the whole point. They don't want to spend 5, 10, or 15 years in court.
No, I'm saying, Nicola,
let's say there's a labor dispute that started when about wrongful termination of contract, and the person which is suing is about 45 years old. He or she started working somewhere else, okay, but that's 15 years of your life that you cannot go back, of stress, of anger, of disappointment, of whatever.
Loss of peace of mind. The most important thing. But I'm saying, Nicola, that cannot be that. I'm saying that cannot be the reason to say why you should go for mediation, because in a way that's like blackmail. Look, we are inefficient. We are not going to give you justice at all because we are going to delay that whole process for 15 years. So this is something that you have an option. Go for it for that reason. That should not be a reason for them to go for it. I'm saying that if you have to create a system on the other end, it is something which they find value in. Finally, it's that. I am saying instead of that, I've been saying this, that let the Chief Justice of the highest court in the land go on to mass media, fold his hand, and say, look, her, it could be her also, Elizabeth, anything. I'm not saying it is him only, her also. Whoever the Chief Justice is of the highest court folds his hand, her hand, and says, look, we are not going to deliver justice. We are inefficient. We can't put a house in order. We are the most inefficient institution in the country. I'm saying there is no other institution which can function that they can function. Who can keep someone hanging for 20 years? Can the government keep someone hanging for 20 years? No other institution can do it. It is only they are getting away because of the whole colonial mindset that they can get away with whatever they want. They are the judges. They sit on a pedestal and everything. Gets them down to earth. They are inefficient. They have to go out and, like I said, fold their hand and apologize and tell them, look, this is a process. All the things, Nicola, you said, all the things that you said about the process, those things, exactly that to the public, and tell them. Then at the same time, the legislation supports that, which I've been talking about. Our legislation, simple, anyone can understand it, simple process, but protect the confidentiality and without prejudice. And the settlement agreement should be as good as a court decree without any other process for the person. So keep it that simple. Both the sides have to work together, and people can actually be told about the process, connected to tradition, connected to what they're doing in their families. Exactly what all you said. I'm saying all those things to be something valued by people, rather than you being inefficient, and your inefficiency is the reason in a mediation to get to a settlement are things where a mediator will tell you, which is where I find the whole concept wrong, that you can't say that to people and be the reason for them to settle it.
Yes, but there's also the issue of us, of ordinary citizens who go to court for everything, for absolutely everything. We're suing family members, we're suing colleagues, employers, we're suing the city because we tripped and fell on the street, and there is going to be a congestion at courts. And then there's a judge. I was talking to a friend the other day about a case, and that's why I'm mentioning the tripping part. The woman was walking on the street and she fell. She tripped and fell. But she is suing the city. The city has a company which deals with damages, and she wants somebody to give her damages, and has a claim for 10,000 euros. That's really big money here, and for some people, and that case is going to last for about 6 years. And there's some judge who will have to get in the medical experts, traffic experts, because somebody has to determine that the woman actually tripped on the pavement, not on herself, and the medical damage that has been. And there's somebody who will have to prove how much money did she lose while recovering. And that's all the damages that need to be proven. And there's going to be a judge who will listen for that sort of case for 6 years, 5, 3, whatever. That's a simple settlement case. I fell. Where did you fall? Right here. And how did you fall? Like this. Okay, well, the damage isn't that big. Let's talk this out. For 2 hours, a really good professional mediator will solve that case in 2, 3, maybe 4 hours. I agree with you that the user is the most important part of mediation. There will be bad seeds. There will be people who are not suited to be mediators, who are trying to find themselves there and who don't understand the process. And they will fail, and that may turn away some users. But in the end, if we all train ourselves properly, if we all ply our trade carefully, mediation should take part. Right now, there's a lot of people here who are waiting to be mediators, lawyers who are waiting to be mediators, but they do not refer the cases to mediation. and they say that somebody has to tell them to refer it. They are waiting for the mandatory mediation part. There is also that part of the legal industry that is there. Somebody needs to tell them what to do and how to do it, and they will do it. They will never question it. There will be people who will question it. Because if I can solve a case as a mediator in a day, and when a client comes in and he's like, okay, so this is a claim for blank, and we will have about 5 court hearings, and we will have 3 experts testimonies, and maybe we'll have, I don't know, 2 more people to weigh in as cross examination. Your total costs are 30% of your claim with my fees. Nobody says that. Nobody says the bulk of money. Nobody explains that to the client. Nobody explains to the client how long will the court hearing last. They will just.
That's what I'm saying, Nicola, that everything that you're going to tell me for them to settle are things connected with the inefficiency or the procedures of the court. We are not showing them the value on the other side of it, that it is something, whatever, I don't know. Look, every matter will be different. I'm not going to say that they will find value, not find value. I'm not going to get into any generalization on that. But I'm saying if this is the only thing we can show them to settle a matter, this is actually, in a way, think of a person who has a very legitimate claim, is pushed into a settlement because the costs and the time shown to that person on the other end is so much. So I want that to be removed. That should not be the reason for you to get into mediation, because what you're going to take out of that, which I'm hearing here, I'm sure you hear the same thing if you have that system there. The things that I'm hearing from the mediation in that court system, people will never ever tell people to use mediation. It's as simple as that. They're not doing that. So
Yeah.
if for 17 years we've had it on our civil procedure code in courts that it should be sent for ADR processes, that one, I mean, look, this is one aspect we've discussed. What we need to also discuss is that, first of all, how much should the courts, in terms of matters, what matters should be going to courts? Because you've made a very important point, that how much time do judges spend on a matter? Now, in a country like ours, I can't say what the situation with the criminal justice system there is. Here, they people who have some time spent more time in jail than they would have spent if they were convicted on day one. Things are really bad. I mean, that's an extreme, I'm telling you. But I'm saying, even for one day, if you can take someone's freedom away, and on the other end, you are so inefficient that you can't show that you can hear the matter. The person is innocent, but you put them into jail. We say that the justice system should be such that no innocent man should be convicted. But
Yes.
during the process, from when the person was put into the jail and you acquitted the person, you've actually taken away the person's freedom. You have, in a way, as bad as what your conviction would be. There's one person was in the trial court, gave the person death penalty. Can you imagine? Death penalty. That matter moved in whatever speed it moved to the Supreme Court. The person was acquitted. Can you see the difference there? He lived his life in the jail on a daily basis, thinking he's going to be hanged. And this took about, I think, 11, 12 years. It's still fast. I think 11, 12 years. So imagine what you're doing there. What business do you have if you are so inefficient to keep someone inside? You have to totally look at that system first. This comes as a secondary aspect of it. For people to find value it, we have to go down to the reasons why mediation got lost. Why did people move away from it? That colonial mindset, that hangover, with the conditioning of the mind. Did communities break up? There's no concept of ownership of communities. There's no social pressure. There could be various reasons on that end. So we're not going into the root of the problem. We are just at this stage, our tank is full. So we need a release. Let's put a hole here and let's get out the thing. That's not what the whole larger ecosystem needs. So I'm saying that look at it from a holistic perspective, because in another 20 years, we'll go through this whole thing, mandatory mediation, and this is going there. All that discussions will keep happening. But the other aspect which I want to discuss with you, and which is also important, is I'm give you an example of India. It's already, like I said, 17 years. At the end of the day, I see the situation today. Mediation outside the court system did not develop. The whole concept of it being free, that aspect is what is being connected to mediation, that is free. So who suffers in the whole thing? The mediator.
Yes.
Why have we, the mediators got lost out in the entire process because the judiciary in some way just wanted to get the matters out. Finally, how does mediation function without a mediator? So I dug a little deeper. Look, I went into the, of course, the US model only because of the years. We have only had 17 years. They had about 45 years. What did we find there? That in the court system, mediators came in because they wanted to be recognized by lawyers to get private work. They did work for free. They were not given private work. They got disillusioned with mediation. They moved out. Another lot came in. So like a Ponzi scheme, that went on. So new and more people came in. That whole development of mediation outside the court system has not happened to the level that I would want it, because it's still not the first port of call. So there is some issue somewhere. So looking at that aspect, and which is now what is happening in India, where the lawyers have taken control of the mediation in the court system. So the mediator is getting nothing. Lawyers are charging that nice fee. And people keep saying that in the US, there are mediators who only advertise also for the lawyers. They're not, for them, that is their client. The client is not the party. It's the lawyer, because the lawyer is going to see who the mediator is going to be. So at the end of the day, if you look at the court system and you look at, I mean, every country will have to get people to tell us about it. But at the end of the day, lawyers take control. They get their fees. Mediator doesn't develop. Is still something that some people are passionate, so we'll go to court and we'll do it for free. So nice. But where does the first stage come in where matters don't come into court? Did you, that whole aspect of developing it outside the court system should have been our concern. So that did not happen, has not happened, and you're not moving in that direction. So the larger thing, the goal, what it should be, is not working out. It's going to be something that people will go through the process. Yes, they will settle because you will show them the other side, that look, these are the costs, these are the time, those aspects. So is that, I mean, I don't think that's the future at all.
I think that's the problem with us mediators. We do things for free. We advertise on behalf of others. And when it comes to developing the process as it should be developed, we do it poorly. When you do it properly, it works and people are happy. But since we are trying to make things happen, everybody is doing it in their own way and according to their own personal belief. But this is a trade, and you have to take your time, learn the process, and when you learn the process and start talking to people, the pre-litigation stage will happen. We all and when because the question is, what are you as a mediator going to do if I cannot and I couldn't have talked it out before? And then most people are stumped. Most people are stumped. They will ask the next question with family members and friends. Do you want me to go and talk to him and maybe try to get this to work? And usually people will say yes. But when you're a mediator, you don't ask that question. You say, I can help you with that, and that's going to cost you that much, and it will be short, and it will be fast and cheaper than the courts, and etc., etc. But what are you going to do if I couldn't have resolved it myself? We all just say, well, I don't know. There's a lot of things I can do.
No, but Nicola, the important thing, let me finish on the court part of it. We have the person the pioneer in India who started the first mediation center in the court. Obviously, this whole free thing happened. Now he's understood that it should be that the people who can't afford it, you provide the mediators at no charge, but people who can afford it, they should be paying market value. Okay, that's his, finally, after 17 years, he's understood that. Damn good. But what is really happening on that end? Why is the court wanting to give it free? I don't know you if you know what happened in Romania. Have you studied what happened in Romania? Elizabeth, yeah, one sec. Yeah.
May I ask you, am I truly understand what are you afraid about mandatory mediation is, I hear you, it's two parts. The first is what mediators don't will get payment, and that if we will use the mediation, mandatory mediation, only when people go to the courts. So that's why mediation will work only on this step, and it will be for free, and mediators can't get any payment.
Look,
Am I rightly understand you?
Look, I'm telling you, I'm putting it into parts. I'm saying that we are telling parties to go for mediation because the courts take too long to decide a matter and their appeals and all. The cost is very high. So you should go for mediation and try and settle your matter in mediation. Is that the right approach? Is that what you're putting a gun on someone's head and saying, look, if you go to this side, these are the costs involved, you are better off settling here? That's that's like you saying, not a voluntary process. It's a gun on your head situation. So that should be removed. Okay, we are an efficient institution. Like I told you, in Germany, when Chuck, I don't know whether you came to Chuck's session in the last symposium. This is what he was saying. He compared Israel and Germany, and he said it has taken off in Israel because the courts are inefficient. It has not taken off in Germany. So if we are saying very nice, mediation is very good, but if people are not finding value in it and they're only finding value in those situations when that gun is put on their head, that's really not fair for them also. It's not a fair thing. I mean, according to me, this is something that they have to find value in, and we have to create that kind of thing or get into the root of the problem if they're not finding value from day one. What are the issues there? Because if we are looking at long term, we have to look at long term. If these short term things we are coming out, so I'm going to get into the second part as to what, Nicola, what happened in Romania? Any idea? What happened there? Basically, what happened there, as I understand, is that this was challenged. Mandatory mediation was challenged only for this reason, because first of all, the aspect of asking parties to pay for something was not going to happen. I mean, I'm not saying in Romania exactly that happened or not. The understanding was they had to scrap the whole concept. And of course, there are thousands of mediators who were there available, finished that whole concept, finished, because the point is they said that courts is where people have come for a certain process.
Yes, but that's the typical lawyer reasoning. And the lawyers in Italy did the same when mediation was introduced as a mandatory initial meeting in 2011. And they went to the European Court of Human Rights and said that this restricts people's right to go to court. And when the court decided in its ruling, it stated that there is no right to go to court. There is a right to justice. And mediation doesn't restrict anybody's right to justice. And you can go to court if mediation doesn't succeed. And lawyers are doing the same dance everywhere. They're going through social media. They're finding somebody who agrees with them just to support them. And when they are talking about mandatory mediation, the opposition of the mandatory mediation or mandatory first meeting, they all sound like flat earthers. They all sound like I don't know, people who are trying to debunk something that has been proven for years and has worked for years, because they all look at litigation as their source of income. And the only thing they can do, and they know how to do, is to give the client the calculation I told you before. 5 hearings, 2 experts, and you have to pay me plus, let's say he has a digital watch and right now it's 1522. So you owe me 5,000 euros plus 1522, you owe me 7,000 euros. And that's the fee. And you owe me 10% or whatever I get you, even if I lose, but the claim is lower, you owe me that also, 10%. And that's and that's what's wrong. That's why people are turning to mediation.
Look, let me tell you that, of course, you are saying that the whole idea is to not the courts, but to get justice. And I am saying this is, of course, by itself, we can have another session on this, because definitely we won't have too much time right now. Whether whether mediation, be it in the court system or otherwise, is access to justice. So we can do a session on that, because that's by itself will be one whole discussion, because finally it comes down to that one basic aspect being that based on that route, then you can send people out and say that, look, you don't have to come to be, I mean, the courts are there, yes, under the constitution they're set up, but we can decide whether you should come into the courts or not. It's not something that you are guaranteed. So if the constitution supports or doesn't support, obviously every country will come up with their own interpretation, and also we won't get into that part. The important thing being that the fact of it being free, one of the reasons is this, that you don't want people to challenge the whole concept, because you have on the other end, the whole access to courts, whatever argument, right or wrong, I'm not going to get into it right now, because that'll be another discussion. But that argument available to people that, look, we have to have an access to the courts, but if you're sending it to the process, we are not going to pay for it. That can be an argument by people. So let's not get into any kind of controversy. Let's give it free to them. There's no concept. They can't at least take this argument. So is one argument gone out of the picture? So that at the end of the day, what suffers? The value of mediation. I'm telling you, there was one person, was a very senior mediator in India. He set up this with a few lawyers got together. They set up a mediation center in the city, doing very well. The court started there with the mediation center in the court, free on there. Look, imagine across the road, you're getting it free. So it closed down. And there was one other mediator from India who was talking about it, that some people came to him with a matter, asked his fees. The lawyers tell them, why do we have to pay him? We'll go to the court and get him appointed as a mediator. so the whole concept around it, the free thing, will always have issues. People will find their ways around it. Lawyers will find their way of telling the clients that, look, you pay us, but don't pay the mediator, because you can get it for free. At the end of the day, mediation suffers because the way people talk about it, the mediator suffers. And for me, mediation without mediator is not happening. That's why it's evolution of mediators and mediation. We can't let mediators get lost.
I would like to weigh in just one more point. We exercise the law of free legal support here. So if you do not have any money to pay for any legal services, whether it's the lawyers or mediation or whatever, you can go to the municipality, and they will provide you with a certification that you do not have the money. So
for legal aid.
Yeah.
That's what no. Now that the whole thing is the
if
free.
you don't
Now
have
there's
money
another
for
discussion.
mediation and the court don't go into court.
No, Nicola, let me tell you that discussion on free and pro bono is another discussion. So that's another session by itself. We already had that session. I don't know whether you heard that. So free and pro bono is another thing. But look, at the end of the day, what we have to look at it is that if you want to develop mediation, look, one is it's a short-term thing. The other is mediation and mediators. That development has to take place. Do you think with that whole concept of getting free mediation and mediators for free, you see an issue there in the long term?
Yeah. Why would I want to do it?
Exactly. That's the point. That's exactly where the point lies. That very casually you come out with a system there. Oh, damn good. You are sending you for mediation. But on the other end, it's someone's livelihood. Can be someone's livelihood. So yes. What are you doing for a person like me who's not going to be connected to any court, is only going to do work outside the court, and every time a person who has, say, as in terms of numbers of years of experience, supposing, let's look at it from that perspective, is going to be available for free in the court system. Are you being fair? So look at the discrimination. This is discrimination by the courts. The other thing I keep saying, you are saying that you are overloaded. One. So is there any other option in terms of what we say ADR? Why is it mediation only? Of course, you have an option of arbitration also. Can you tell people
assisted negotiation, conciliation, whatever?
Exactly, lots of options. Are you telling people to go for that process? Are you making that mandatory? I've never heard of mandatory arbitration. And for the arbitrator in that, free arbitrator you will get. Arbitrator you will get free. Why is a mediator you will get free? Make it mandatory for you have to go for arbitration or mediation, one of the two. Otherwise, if you want to stay in litigation, the lawyer will also get only that much amount, what the mediator and the arbitrator get. Be fair across the board, because you're talking about access to justice. All three can become access to justice. So why is it the different fees for all of them? Lawyer can charge what they want in the litigation. Arbitrator can charge what they want, but the mediator is not supposed to. They're supposed to give it free.
I agree.
Be fair. Be totally fair about it. Look, we are overloaded. Okay, you are not wanting to go and apologize for that. You don't want to put your house in order. Don't do it, because you are the judiciary. You get away with it. But on the other end, that layer that you are creating and telling that all the justification you are giving for sending them out of the court, give them all the three options, and all of them should cost the same to them. Then I will say you're being fair. Just because the lawyers have a lobby and you will never be able to control their fees, you are going to put it down to the other side, because arbitrators also will be people who have a lobby. Why is it that mediators don't have a lobby? Mediators, if they are going to say we are not going to give it for free in the courts, let them do that. I'm saying all the mediators in the court stop their work up till they don't get paid market value. Let it happen, no problem. And then whoever comes in, it is a choice by the parties. Then the whole voluntariness about it and party self-determination, that you can choose whatever mediator you want, then things start happening. On that point, yes, things will start happening. Not in the way that whole thing is structured today. I don't see that being something that you are being fair on anyone on that, be the parties or the mediator or mediation. None of the three things. I don't know. What do you feel? Yeah. Chalo, if you can stop at the agreement. We are good at agreement, Elizabeth. Just say I agree. Then we'll stop the session. say I agree.
I agree to stop the session.
Very good. Thank you very much, Nicola. Elizabeth.
Thank you, Vikram, for having me. Thank you, Elizabeth, for weighing
wonderful
in.
Discussion. Yeah,
Yes.
we will break it up into other parts into the discussion. If you have time, we can fix that up. So let me cut this down because Andrea should be coming in now. So thank you very much.
Okay. Thank you.